My name is Michael McFadden. I'm a partner in the law firm of Ogilvy Renault, soon to be Norton Rose, and practice in the Toronto Employment and Labour Law Group. I and my colleagues perform a significant volume of work on behalf of the Crane Rental Association of Ontario and are familiar with the operations of your crane company through that work. I'm here today to speak to you briefly about Bill 160 and your harassment and workplace violence policy. The Ontario Occupational Health and Safety Act applies to violence and harassment in the workplace. This presentation is part of your company's training and commitment to maintaining a workplace where all employees are treated with personal and professional respect in an environment free of unlawful violence and harassment. The Ontario Occupational Health and Safety Act applies to violence and harassment in the workplace. This presentation is part of your company's training and commitment to maintaining a workplace where all employees are treated with personal and professional respect in an environment free of unlawful violence and harassment. I would next like to talk about some important definitions in your policy. First, the term workplace. The workplace includes anywhere you are being directed or paid to attend at work. The workplace extends beyond the job site and can include anywhere you are on company business. This includes meetings or any other location business is being conducted. If harassment or workplace violence occurs outside the workplace but affects the work environment and adversely affects employee relationships, it may also be considered to be within the scope of your company policy. Next definition. What does the term harassment mean? The term harassment means engaging in a course of vexatious comment or conduct against a worker in a workplace which behavior is known or ought reasonably to be known to be unwelcome. Now, what does the word vexatious mean? That means that it's repeated, it's deliberately annoying, and as I've said before, it should be obvious that it's not welcome. Harassment can involve unwelcome words or actions that are known or should be known to be offensive, embarrassing, humiliating, or demeaning to a worker or group of workers. It can also include behavior that intimidates, isolates, or even discriminates against the targeted individuals. This includes bullying, freezing out a coworker, and intimidation. Verbal, physical, or visual behavior or actions where the purpose or effect is to create an offensive, hostile, or intimidating environment. It is not limited to certain prohibited grounds or personal characteristics. Gestures, actions, language, any conduct that is known or ought reasonably to be known to be unwelcome is prohibited. It can even include a single incident, but it can also include a pattern of behavior. It can be committed by anyone, an employee, supervisor, contractor, or visitor. Conduct may constitute harassment whether or not the person behaving in that way intends to offend, and it does not matter if the person responds with silence or does not complain. I'd like now to turn to some examples of prohibited harassment. Prohibited harassment includes racial, ethnic, religious, age-related, or any kind of sexual jokes or insults. Distributing or displaying offensive or obscene pictures or cartoons can constitute harassment. It is also workplace harassment to use voicemail, email, or any other electronic device to transmit false, derogatory, or discriminatory information. Questions, discussions, or jokes about sexual activities or sexual orientation are forms of workplace harassment. So are physical or verbal abuse or threats, or making repeated unwelcome sexual comments, advances, innuendos, or using obscene gestures. Workplace harassment will also include unwelcome physical conduct, such as hugs, kisses, touching, or patting. This would be a good point to describe what is not harassment. Harassment does not include normal work direction, work allocation, or discipline being imposed on an employee by a supervisor. It does not include being unhappy about a disagreement with a coworker. Normal business activities, such as performance improvement initiatives, enforcement of policies or rules, enforcement of the collective agreement, are not forms of harassment under your company policy. I would now like to turn our attention a little bit to some of the specific features of your company's harassment policy. This policy includes and applies to not only employees, but other vendors, contractors, clients, and customers. You should also know that retaliation is prohibited under this policy. You cannot retaliate against a person for making a good faith complaint under the policy, regardless of the outcome of the policy, nor can you retaliate against a person for participating in an investigation under the policy. Under this policy, any complaints will be promptly investigated and appropriate follow-up action will be initiated. Any violations of this policy may result in disciplinary action up to and including dismissal. This policy is essentially a zero-tolerance policy. I'm next going to talk about what you should do if you believe you have been harassed under this policy or you've seen someone else being harassed. If appropriate, you should make it known to the harasser that the behavior is unwelcome or offensive. Keep a record of the event if you can. You must report the incident to your supervisor, foreman, or some other senior company representative and discuss it fully. If the harasser is your supervisor or foreman, then report the incident to the general manager or the site manager. I'd next like to talk about what you can expect from a harassment investigation. As I've indicated before, all complaints will be promptly investigated. The company will conduct a harassment investigation. This investigation may involve interviewing the person alleged to have been harassed and the harasser. It may also involve interviewing persons who may have witnessed the harassment and finding out what they have to say. In the course of a harassment investigation, it will be kept as confidential as possible. And I reiterate, retaliation during an investigation will not be tolerated. Now we're going to go to a different area under your policy, and that's workplace violence. How is that defined? Workplace violence is the exercise of or attempt to exercise physical force by a person against a worker in a workplace that causes or could cause physical injury to the worker. Any statement or behavior that a worker could reasonably interpret as a threat to exercise physical force against the worker in a workplace that could cause physical injury to the worker is also considered workplace violence. I'd like to talk about some examples of workplace violence. They include verbally threatening to attack a worker, leaving threatening notes at or sending threatening emails to a worker or to a workplace, shaking a fist in a worker's face, wielding a weapon at work or using or threatening to use any object as a weapon, throwing an object at a worker, kicking an object that the worker is standing on, such as a ladder. All of these things would be considered workplace violence. It would also include using your crane in a manner that another worker might think is threatening. You should know that a person need not intend to actually hurt another worker to be found to have engaged in workplace violence. Now I would like to talk about what does not constitute workplace violence. Having a non-confrontational disagreement with a coworker, disliking or being unhappy about a work assignment, having a disagreement regarding your work assignment with your supervisor, being subject to discipline for a workplace infraction or poor work performance by your supervisor. Under your company policy, domestic violence may be considered workplace violence. By domestic violence, what I'm referring to is where a person who has a personal relationship with a worker, such as a spouse, former spouse, current or former partner, or a family member, engages in any activity which may physically harm or that person attempts to threaten to physically harm that worker at work. In these situations, domestic violence is considered to be workplace violence for the purposes of your policy. An employee that is concerned about an employee in a domestic violence situation should bring this to the attention of the company. Any employee who has a valid restraining order against any other person must bring this to the attention of the company immediately. The company will consider appropriate measures to put in place in such cases. Your company policy requires that you report any workplace violence to management. It would be a good idea if you kept notes of what you saw, and of course, if there has been an injury, medical attention should be sought immediately. In conclusion, keep the following main points in mind. All employees under the company policy are entitled to equal treatment and to work without harassment or the threat of violence in the workplace. All employees are entitled to bring a complaint under the policy to the attention of supervision or management. All complaints will be investigated thoroughly, and company policy prohibits any retaliation for any complaint made in good faith. The company does not tolerate violence or harassment, and any employee who breaches the policy in that regard is liable to be disciplined up to and including termination of employment. The company will take all reasonable steps to protect workers from violence or harassment in the workplace. Thank you very much for your time today.